All right, we can go off the record. So here's my question. Why the tears?
I'm signing my life away.
Well, I mean, this is your choices. I mean, this is over you taking some beer with a gun in your hand. Was a beer worth 15 years of your life? Well, that the stipulations that you agreed to, I've read it, and you put somebody's life in fear of their life because you wanted what they had. If you want to cry, cry for the person that you put their life in danger when they're just trying to do their job. If people don't want to go to prison, people shouldn't do prison things.
Today, we're in Judge Boyd's courtroom, and this defendant suddenly found his emotional side the moment he got caught. The tears are pouring, but none of it feels real. No actual remorse, just a performance. And Judge Boyd? She's seen this play 100 times. This isn't her first sympathy act. He's trying to sell a whole tragedy, but she's not buying any of it. You can already feel the tension building because she's not entertaining the act at all. So now the question is, do those tears help him or make things even worse? Let's get into it.
And are you Joe Jimenez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Jimenez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, ma'am.
All right. And there's also an enhancement paragraph. Are you proceeding on the enhancement in each count?
So just regarding count one, regarding count two.
Okay, I understand. All right. All right, Mr. Jimenez, did you review the document entitled Court Admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? In count one, you're charged with aggravated robbery. If the state is able to prove up the enhancement allegation, your range of punishment is anywhere from 15 years to 99 years or life, and a possible fine up to $10,000. In count two, you're charged with unlawfully carrying a weapon with a felony conviction. All right, just one moment. You're charged with unlawfully carrying a weapon with a felony conviction as a third-degree felony. The range of punishment for that offense is anywhere from 2 to 10 years. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 15 years in count one, and in count two, they're not. That is, you're right. Okay. So according to the plea bargain agreement, you're to be sentenced to 15 years in count one. And count two, you're to be sentenced to 10 years. Counts one and counts two will run concurrently. Is there anything, because I'm trying to do it from memory at my first glance of the paperwork. All right, and there's a $2,000 fine. Did you understand that to be your plea? Defense is at the plea.
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to count one, how do you plead? Guilty, not guilty, or no contest? To the enhancement under count one, how do you plead? True or not true?
True.
To count two, how do you plead? Guilty, not guilty, or no contest? State any evidence.
The offer states one attachment.
No objections, Your Honor.
All right, states you may be excused. Did you review the waiver and consent to stipulations of testimony with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
This guy is facing a possible life sentence for aggravated robbery, and somehow still thought it was smart to pick up a gun afterward and stack even more charges. Like, what was the plan there? At that point, it's not about failing to learn a lesson. It's about not even thinking at all. You're already staring down life, and then you hand the prosecution even more to work with. Now he's sitting here crying, and it's hard to tell if it's real or just for show. But let's be honest, anyone would panic hearing life sentence tied to their name. The only reason he's not completely cooked is because his lawyer worked out a huge deal. 15 years on one count, 10 on another, running together. That's a massive break. So now it comes down to this. Does the judge accept it or decide his decisions were so reckless that she goes above it? Because going from life to 15 years? That's a win. But the craziest part is he's acting shocked, like he didn't create this situation himself.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of counts 1 and counts 2. The court will find you guilty of counts 1 and counts 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Are you waiving PSI?
Yes, Your Honor.
All right. In count 1, the court will sentence you to 15 years in the prison, give you credit for any time served. The court will sentence you to 10 years in count 2, give you credit for any time served. In count 1, there's an affirmative finding of deadly weapon. Counts 1 and counts 2 will run concurrently. There's a $2,000 fine. Is there anything else with regards to sentencing?
Yes, Your Honor. He had a federal case that he got 17 months on. He entered custody on May 12th of 2022, which was 3 weeks after this case.
Mhm.
And he's been in continuous custody since. I believe he was released from Karnes County, which is the federal penitentiary, or their holding cell actually, on September 24th, 2024. But he has been in continuous custody since May 12th, 2022 to present.
Oh, he'll receive credit for that time.
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So here's my question. Why the tears?
I'm signing my life away.
Well, I mean, this is your choices. I mean, this is over you taking some beer with a gun in your hand. Was a beer worth 15 years of your life? Well, the stipulations that you agreed to, I've read it, and you put somebody's life in fear of their life because you wanted what they had. So what I can tell you is, if you want to cry, cry for the person that you put their life in danger when they're just trying to do their job. If people don't want to go to prison, people shouldn't do prison things. Well, I mean, you had a chance to be in the free world, to be with your children and your wife, but you chose this. So this is where we are. If you would have gone to a jury trial and a jury would have found you guilty, let me just tell you, based on my experience, you know what a jury would have done? They would have looked at your tattoos. They would have known what those tattoos meant, because they would have been told what those tattoos meant during punishment, and they would have gave you life, and they would have went on their way. They would have gave you life on that case. And for the gun case, they would have given you the maximum. So if you don't want to be standing before a judge crying about your wife and children, then stop doing this. All right. Good luck to you. Oh, thank you.
Thank you.
Oh, thank you. You have a good one.
I thought this was some major robbery case with how serious everything sounded, and then it turns out he threatened someone over a beer. A beer, that's what all this comes down to. Risking your entire future over something that costs a couple dollars. That's not just bad judgment, that's zero control. And when the judge told him to cut the tears, she meant it. Nobody in that room was buying it. You don't get sympathy after making a decision like that. Honestly, he's lucky that deal capped at 15 years. If this went to trial, he could have easily been looking at life without hesitation. It really makes you think how many lives get wrecked over one stupid decision. So what do you think? Does 15 years fit something like this? Or is it too much or not enough?